Good afternoon, everyone, and thank you for attending this free talk on equality, diversity and inclusion for charities. My name is Debjani Biswas-Hawkes and I work on the not-for-profits programme here at LawWorks, and I'm delighted to be joined today by Kathryn Finch, who is a lawyer, a consultant and founder of Quartz Consulting and Coaching. And Kathryn is going to be talking to us today about equality, diversity and inclusion for charities, and how it's not just a nice to have or a set of buzzwords, but actually is enshrined in the law. So Kathryn, hi, over to you.
Debjani, and thank you so much for having me. So today I'm excited to be taking you through the duties and obligations imposed on charities and organisations under the Equality Act 2010. We'll talk about the Act, how it aims to prevent discrimination, and some ways in which charities can make sure they're complying with their duties.
So to start, could you please give us a little overview of what the Equality Act 2010 is?
No problem. The Equality Act 2010 is a piece of legislation which applies to England, Scotland and Wales. It entered into law in 2010, as the name implies, and was designed to harmonise the various laws surrounding anti-discrimination in Great Britain. So in that sense, it makes our lives easier because with some exceptions, it means that we can actually just look in one place. For the sake of this introduction, it means that it's illegal for organisations to treat someone unfairly on the basis of certain protected characteristics that they might have. It's important to understand the blanket requirements under the Act before we go into the specifics of how it applies to charities, which can be slightly different.
Okay, and would you mind just walking us through what those protected characteristics are?
Of course. The protected characteristics under the Act are age, disability, gender reassignment, marriage or civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. People associated with those characteristics are also covered by the Act, as well as people who are treated unfairly because they are perceived to have one of those characteristics. So, for example, helpers and people with invisible disabilities are also covered.
Okay, that's pretty clear. So next, can we talk a bit about what behaviour is prohibited under the Act?
Yes, keep in mind that there are some exceptions for charities, which I'll go into later. But for now, I think it's helpful to go over some of the blanket requirements so we can have a clear view of the Act requirements before we dive into exceptions. The Act focuses mostly on unlawful discrimination, harassment and victimisation. I'll go into a bit of further detail regarding what constitutes discrimination, as I feel it's important to understand the practical meaning of these words. Although there are different approaches to categorising the unlawful discrimination under the Act, I put together the key considerations it's important to have in mind when an organisation considers their obligations under the Equality Act. So I'll go through each of these requirements in turn. So starting with discrimination, number one is that you cannot directly discriminate against somebody. So this, I think, is probably the most obvious one. You mustn't treat a person worse than someone else because of a protected characteristic. So an example of this would be refusing to help a woman because she's pregnant. Number two, no indirect discrimination. Indirect discrimination is when you do something to someone which has or would have a worse impact on them and other people who share a particular protected characteristic than on people who do not share said characteristic. An example of this would be requiring a minimum height requirement for a job where height is not relevant to carry out the role. This would have the likely effect of discriminating disproportionately against women and some minority ethnic groups, perhaps, as they are generally shorter than men. It is an important factor of indirect discrimination that in order for something to qualify as indirect discrimination, the action cannot have an objectively justifiable reason. So in our example, if there is an objective reason why someone working in the job needs to be of a certain height, it would not be classified as indirect discrimination. It's also important to note that this definition includes making a decision or applying a rule. So number three, no discrimination arising from disability. Again, I think this is more on the obvious side. You must not treat a disabled person unfavourably because of something connected to their disability, where you cannot show that you're doing it for an objectively justifiable reason. Although it's important to note that this only applies if you know or could reasonably be expected to know that the person is disabled. 4, not treating people worse because of their association with a person who has a protected characteristic. So we talked a little bit about that a minute ago. This requirement really speaks for itself, I think. Even if a person does not themselves have a protected characteristic, you cannot treat them less favourably because of their association with someone who does. And we'll speak about this a little bit more when we come to victimisation. And number 5, not treating people worse because of an incorrect perception that they have a protected characteristic. Again, relatively self-evident. Example would be firing somebody because you think they're gay, whether or not they are actually gay. It does not matter whether the person is in fact gay in this scenario. The fact of them being fired due to this perception is a contravention of the rules of the Act. And lastly, for our discussion on discrimination, we must act proactively to ensure that disabled people are able to use your services as far as reasonable to the same standard as non-disabled people. Reasonable adjustments must be made in order to allow for disabled people to access and use your services to the same standard as non-disabled people. It is not sufficient, and I think this is an important point, to wait for these adjustments to be requested by disabled people. It's required that you think in advance about what people with a range of impairments might reasonably need. I think it often includes adjustments for the visually impaired, the hearing impairment, mobility impairment, or a learning disability. So if we move on to harassment, again, I think this might be, especially now, more in the evidence side of things, but no harassment. Harassment is completely banned under the Act. It can be defined as an unwanted conduct that has the purpose or effect of creating an intimidating, hostile, degrading, humiliating, or offensive environment for the victim of harassment, or something that violates their dignity. And of course, harassment can be sexual in nature. Then victimisation. You cannot treat someone unfavourably because they have taken or might take action under the Equality Act or are supporting someone who is. And I think that's an important thing to keep in mind as well.
Thank you so much, Kathryn, for going through that in a really thorough manner that's easy for everyone to understand. We now have a bit of a groundwork for the kinds of behaviour that go against the Act. So now I want to know, who does this actually apply to? Presumably not just the heads of organisations.
It's a great question, Debjani. Of course, it's not just how you personally behave that matters. Where your organisation employs people or has people who are carrying out your instructions, also known as your agents, where they unlawfully discriminate, you can be held legally responsible for their actions. This makes sense if you think about it. Often discrimination is structural in nature and not just direct and interpersonal. The person in charge in an organisation is seen as the principal, and they are responsible for setting the rules of the organisation. Now, as we'll discuss later, this doesn't mean that it's just the heads of organisations that can be liable, but this is important to keep in mind. Where you use other people to provide services or carry out public functions for you, you are legally responsible for any acts of discrimination, harassment, or victimisation carried out by them. This includes employees and your agents. So that's important to make that distinction. So I think a lot of people think that it's just their employees, so people who are under contract, who they might be liable for, but this covers anybody, as we'll discuss a little bit later, anybody who's carrying out your instructions, acting within that role. So like I said, this is even true when they don't have a formal contract with you. For your employees, as long as they were acting in the course of their employment, i.e. doing their jobs, and for your agents, as long as they were acting within the general scope of your authority and carrying out your instructions, you'll be liable for their unlawful discrimination. It doesn't matter whether you knew about it or approved of it, you may be liable. It's also important to note that if an employer or principal instructs, causes, or induces a worker or an agent to discriminate, harass, or victimise another person, both the person receiving the instructions and the person on the receiving end of the unlawful behaviour might have a claim against the employer or the principal. This applies whether or not the instruction was carried out.
That sounds really quite serious. Are there any circumstances in which you won't be held liable?
Yes, it's good news, yes. If you can show that, 1, you took all responsible steps to prevent a worker employed by you from acting unlawfully, and 2, the relevant agent acted outside the scope of your authority, you will not be held liable. Obviously, this won't be the case where an employer has given a direct instruction which would result in unlawful discrimination, but it's important to keep in mind, and we'll talk about that a bit more as we go on.
Brilliant, that's useful to know. So how would you recommend that organisations reduce the risk of being held liable?
Well, the simple answer is making sure that you tell your employees or agents how they need to behave to avoid unlawful discrimination, harassment, or victimisation. What you can't do is contract out of the Equality Act applying to your organisation. Even if you do include a term in your terms of service or employment contracts, it won't have any effect. Make sure that your employees know the requirements applying to face-to-face interactions and internal policy considerations. It's important that you understand and ensure that your workforce understands how equality law applies to their work. Planning is key.
And how should they do that?
Well, there are a few different approaches. A good rule to follow is start as you mean to go on. So when people start working for or with you, to make sure that you tell them what your organisation's standards are and how they need to behave towards the people using your services. It's important that you make sure that this information has been understood and absorbed, and it's definitely worth checking in with your workforce periodically to make sure they're still aware of their duties. Education on equality can take many forms, of course. It's a good idea to have a formal written standard of behaviour to which your employees and agents can refer as they perform their work. This can take the form of a formal EDI policy or an anti-harassment policy, and it's often the simplest way of keeping people up to date with their duties. Often employers reference these policies in their employment contracts, which can also be very helpful. Speaking of contracts, having written terms of employment or formal contracts with contractors and volunteers can be a useful tool in making sure that EDI is not overlooked. Training and monitoring within organisations is also key. You may want to do this internally or work with a professional who specialises in diversity training. Additionally, having clear internal policies to mitigate against any poor behaviour, for example, a team that investigates complaints and responds to them, is also very important. The key to remember is having a proactive approach and making sure it's up to date and constantly reviewed amongst staff is the easiest and most practical way to ensure mistakes aren't made.
Thank you so much. And that's now really clear from the organisation's perspective. But is there anything that you'd want to communicate to individuals?
Yes, as I mentioned before, although your employer might be liable as your principal, there are situations in which you might be held personally responsible for discriminatory behaviour. As we discussed previously, it's possible for employers to show that they've fulfilled their duties and that individuals working for them have acted in a way that was specifically prohibited by the organisation. In those circumstances, individuals can be held personally liable, where your duties have been clearly communicated to you and you go against those rules and or your actions are outside the scope of your duties, you may be liable.
Okay, thank you so much. I think that's given us a really good general grounding about the Act. But what about specifically charities? Does this also apply to them?
Again, the short answer is yes, but with some exceptions. Your charity or organisation will be affected by the Equality Act if it employs people, has volunteers, is an association with more than 25 members, provides services, sells goods or offers facilities, even if you don't charge for these, and or carries out public functions. If you're an organisation of fewer than 25 people, it may not technically affect you, maybe, but it's worth following these requirements as early as possible to avoid any discriminatory behaviour becoming embedded in the functioning of your organisation.
Brilliant. And a moment ago, you talked about exceptions. What are those?
Yes, and we finally come to the exceptions. Well, the Act recognises that the goals of some charities are to compensate for disadvantage, and because of that, there are some exceptions which apply specifically to charities. Before we go into detail, though, it's important to note that it's never permitted, ever, to discriminate based on skin colour. So, moving on to the charity exception. The charity exception allows charities to restrict the people they benefit, but only, and this is very important, only if the restriction of benefits is specified in its governing document or its constitution. And it's either A, to prevent or compensate for a disadvantage, or a proportionate means of achieving a legitimate aim. And I think it's worth going into these in some more detail, as this is a very important point to wrap our heads around. Before we start though, we need to note that charities who wish to rely on this exception must be able to explain and justify their policies and actions which go against the Equality Act. They must essentially be able to not only rely on the exception, but justify why they rely on the exception. They must be able to show how the restriction is fair, balanced and reasonable, how that's a fair, balanced and reasonable way to bring about a legitimate objective, it's important that they must be able to identify this objective. That seems obvious, but you would be surprised. So looking at this in a little bit more detail, if we take the first branch of that test first, test A, preventing or compensating for disadvantage. So this is understood to mean when you're restricting a benefit, your charity trustees should be able to, one, identify the disadvantage and be able to show evidence of it, and two, show how the benefits offered by the charity would help address this disadvantage. So, and a good example of this would be trying to work to help people of Afro-Caribbean descent enter the legal sphere, for example. You'd have to be able to clearly identify what your goal is and be able to find and show evidence that Afro-Caribbean people are actually disadvantaged, so that the justification and the objective of your charity is justifiable. Evidence should be current. If circumstances have subsequently changed and the disadvantage no longer exists, the charity will no longer be able to justify restricting its services. So moving on to test B, a proportionate means of achieving a legitimate aim. Your trustees should be able to, one, identify a legitimate aim, as we've spoken about before, and two, show that the means being used are proportionate. So to think about proportionality, some good approaches are asking these questions. Is there a reasonable, convincing, substantive justification for this restriction? Have you considered whether a less discriminatory way of achieving the same exists and may be applied? And finally, we'll talk about the religious exception quickly. Now, I'm going to touch on this briefly. It's a very complicated area, and I would recommend, if you think this applies to you, that you go off and do your own research or talk to a professional in this area. So if your charity is designed to advance a religion or a belief, or have certain religious goals, it may lawfully discriminate against people with certain protected characteristics. In this case, the relevant characteristics are religion and sexual orientation, but this is only in some very specific situations. Again, very complex issue and outside the scope of this talk, so we always recommend getting tailored advice. And other possible exceptions include schools, further and higher education, and positive action. But again, we'll put that in their own box for now. So just to summarise and to reiterate, if the Equality Act applies to you, you have a duty to not discriminate and to ensure that your colleagues and workers also do not discriminate. If you do have a goal which inherently involves excluding certain groups, this must be included in your constitution and be actively justifiable with supporting evidence.
Thank you so much, Kathryn. So we're coming to the end of our talk. Is there anything else that you think it's important for people to know?
Yes, this is a really broad topic, so it's important to take the time to think about your organisation and its obligations. It's also important to note that if you provide a public service, it will be subject to the public sector general equality duty to avoid unlawful discrimination, harassment and victimisation, to advance equality of opportunity between groups, and to foster good relations between different groups. You should check whether any public service you carry out means that you have this duty. And just in general, you should really think holistically about your organisation to see how the Equality Act might apply to you.
Thank you so much, Kathryn. That was incredibly insightful, and I loved your, practical examples. I'm sure the charities watching this will go away and have a really clear idea of what to do and what not to do going forward. So thanks again for sharing your expertise with us today.
Thank you very much for having me.